Hello, everyone. Welcome to Court with Krissy. Quickly rising the ranks as the top judge that I would not want to piss off, it's Judge Wiggins. And I think I've also found someone that needs to retire before Attorney Karen. Gasp. I know, it must be bad. So you're going to like it. Court with Krissy is now in session.
Matthew Edwards. Court calls the people of the state of Michigan versus Matthew Joseph Edwards, case number 25781 SM. Is Mr. Thomas's case?
Yeah.
Yes, Your Honor, it is.
All right. We'll pass on this one for right now because I know he's talking with Mr. Willett. Sir, if you want to go back out and have a seat. Court calls the people of the state of Michigan versus Donald Marion Fenton, case number 25542 SD. Appearances, please.
Nate Carnes on behalf of the people.
Good morning, Your Honor. George Serkin on behalf of the defendant.
Mr. Serkin, why are you not here?
Your Honor, I was informed yesterday in the afternoon by the clerk to be here at 8:30, and unfortunately, it takes me over 4.5 hours to drive. I could not make those kind of arrangements on such a short notice. And the problem also is, Your Honor, that I have a number of motions to file next week, and because of the holiday on Monday, I have to get them out today or tomorrow. I would always—
Mr. Serkin, you received a notice back on April 16th of today's date.
Your Honor, if I may, my recollection and my notation in the calendar was that it was going to be on May 22nd. And also on May 29th, we're going to have a final pretrial. My client also said he made a note of that date. Now, when I filed my motions last week, I received—
Yeah, we'll get to your motions in a minute. Where are we at with that?
All right, well, here.
Does not make sense to me.
Your Honor.
Mr. Serkin, hold on.
Yes, Your Honor.
I don't show that it was ever set for the 29th. We have the final pretrial that was set for today at 8:45, and then the motion hearing that was set yesterday at 9:45.
Yeah, so my clerk is telling me, as is my file, we were never set for a final pretrial next week, that we are set, the notice in the file is set for today at 8:45. That was sent out on April 16th.
No. Your Honor, I received the court notice yesterday with the date of May 21. I have the envelope. It was postmarked May 20th.
It was, and my staff tells me they had a telephone conversation with you about that date being set.
A telephone conversation to set it to 9:45 instead of 8:30, and I agreed. Your Honor, I was in the Oakland Circuit Court yesterday with a case that was set over 2 weeks ago. If it was going to be on May 21, I would not have agreed to that, Your Honor, and I could not have been in two places at one time. You may check with the Oakland County Circuit Court. I can give you the case number. I can give you the name of the judge. I was in court yesterday for a motion hearing that was scheduled over 2 weeks ago. So if
my staff tells me that they mailed notice of yesterday's motion to you after having a conversation with you, advising that that time was okay. And then we're still here today and you're not.
Your Honor, the only notice I received was the notice I received yesterday. And that notice was received yesterday, and I have the envelope showing that it was postmarked on May 20th. If I have an opportunity to—
For what day?
Person, I will bring it with me, Your Honor.
What day did you that notice that you received that you just referenced, what hearing was that for?
Hold on. Motion hearing.
Okay, so that was yesterday.
9:45.
That was yesterday.
Yes, that's what the
When did
notice
you
says.
receive
I
when did you
received
receive
this yesterday, Your Honor.
Sir, let me answer the question, ask the
Go ahead.
questions, all right? You're
Yeah,
finding
yes, sir.
yourself very close to contempt.
I'm sorry.
When did you receive notice of today's hearing?
Yesterday in the afternoon.
Today's hearing, you received notice
Well, no,
yesterday.
not today's hearing. I'm sorry. I had a conversation with the court clerk yesterday about today's hearing.
Yeah, when you advised them that you would be appearing by Zoom, and I said, no, you're not. The question
understand,
is,
Your
when
Honor.
did you receive notice of today's hearing?
It was about 2:00 in the afternoon.
That's when you had the conversation with my staff. When did you
Approximately.
receive notice on paper of today's hearing?
Verbally, yes.
No, on paper, when did you receive it?
Receive what, Your Honor?
Good God. When did you receive on paper the notice of today's hearing?
Nothing. I have not received anything on paper of today's hearing.
Then how did you know to call my staff yesterday and tell them that you were going to appear by Zoom?
That's correct.
All right. All I can say is it's a good thing you are not present in my courtroom today, because you would be finding yourself an inmate at the Wexford County Hilton. What we're going to do is we're going to set this for next week on Wednesday. We will address your motion and we will address the final pretrial. That will happen at 11 o'clock. And if that doesn't fit with my docket, we'll squeeze it in at 11 o'clock. Both of you will be here. If you're not, or if I don't have good reason for you not to be here, presented to me in advance, you will be in contempt of court. Do I make myself clear?
Yes, Your Honor.
All right, we're adjourned.
Thank you.
It's because your government employees shit don't stink.
All right, this is the people of the state of Michigan versus John Stephen Bozac, case number 252016FY. We're here for an arraignment. Mr. Bozac, did you have the opportunity to meet with somebody from the public defender's office today?
Yes, Your Honor.
I have a complaint that alleges that on or about May 21st, 2025 in Herring Township of Wexford County, it is alleged that you did commit domestic violence as a third offender notice. That is a 5-year felony and or a $5,000 fine, and a consecutive sentence may be imposed if the assault was committed in a place of confinement. Additionally, the prosecution has charged you as a habitual offender fourth notice. That means that in your past, you have at least 3 prior attempted or completed felonies. That makes that 5-year felony a life offense. I'm not asking if you agree with the charges, but do you understand the charges and the potential penalties?
They're absolutely false.
I understand that's your take on it. My question is, do you understand that that is what they have charged you with and what the penalties are?
Yes, Your Honor.
All right. On felony complaints, you have certain rights. You have the right to remain silent. Anything you say or write can and will be used against you. You also have the right to have an attorney present at any questioning that you consent to, and you have the right to stop any questioning. You also have the right to be represented by an attorney at all phases throughout this process. And if you could not afford an attorney, one would be appointed to you at public expense, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
Appointed attorney, sir.
I realize, Mr. Harrison, he's still under he's on another case. He's one of your clients, or at least your office's client.
I believe he's represented by Mr. Hartel. There's just a couple of days in between.
Yeah, I think we're about 2 days.
Okay.
The court will make an appointment or a referral to the public defender's office for the appointment of an attorney. Will enter a not guilty plea and will set the matter for a preliminary examination. A preliminary examination is a hearing that's held here in the district court within 21 days. At that hearing, the prosecution will be required to prove two things. One, probable cause that the crime had occurred, and two, probable cause that you were the person who had committed the offense. If the prosecution is not able to do that, the case would be dismissed. If they are able to do that, you'd be ordered to be bound over and stand trial in circuit court. Prior to the preliminary examination being held, there'll be a probable cause conference. Probable cause conference is where your attorney and a representative from the prosecutor's office will meet and see if there's a way to resolve the case short of going to trial. You also have a right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Counsel, I show in 1979 a malicious destruction of property over $100, 1990 false pretenses over $100, 1996 larceny by conversion over $100, 1998 an aggravated domestic assault, 1998 a domestic assault, 01 operating while intoxicated, 01 a CSC 2, 13 an attempted violation of SOAR duties, in 14 a larceny less than 200, in 14 a resist and obstruct, in 15 a stalking, in 16 an OWI 3, in 17 an operating without insurance and a driving license suspended, in 18 a fail to comply with SOAR registration, not shown in the CCH, but it appears in our local records. 15 there was a trespass. In 1998 there was an operating while impaired. Defendant currently is on bond in Lake County for, if I recall correctly, it was an operating while intoxicated. And he's on bond with us from 2 days ago, I believe, for disturbing the peace at the hospital. Mr. Harrison, any comment regarding bond? And that bond amount was $1,500.
And Mr. Bozac does present some unique challenges to both the court system and the jail. He is 80 years old. He has multiple layers of disabilities, of a 100% disabled military veteran. And he does have an injury to his neck currently that he believes needs some medical attention as well. I realize the dilemma that he presents, Your Honor. He's difficult to manage in the jail because of his physical conditions, but he appears to be, at least on paper, some kind of threat. I don't believe that to be the case, but that is definitely the way that the charges present themselves. He was able to post one bond. I believe it would be a financial hardship on him to have to do it again under the circumstances. I don't believe, because he is on bond in another file, that there would be any consequences flowing from that if he were to be released PR on this file.
Mr. Sharkey?
Yes, Your Honor. Given the nature of this case and the fact where he was has been alleged to have assaulted a caregiver, that is particularly disturbing to us, and along with the history of domestic violence, as well as the habitual court charge, we do believe that he is a threat, and as such, we would like to request that for bond, he be required to have no contact with the victim, and that the bond be set to $20,000.
Thank you. Mr. Harrison, do you know, is there any guardian or conservatorship involved here?
I'm not at all certain. Again, those are details that would not seem to be difficult to ferret out, but in this particular case, there are some obstacles in the way of us finding good information like that. I would believe that he would have at least a guardian, but he was not forthcoming with that in the jail.
Mr. Bozac, do you have a guardian?
I have a legal guardian in relation to Jerry Banzel that lived in Grand Rapids, because I lived in Grand Rapids that time. I moved to Lake County and on Pine River. It took me 8 years to get out of a wheelchair. Now I'm back in it again. I've had 3 strokes in the last 10 years. I had a heart attack 3 weeks ago. I had 2 stints in Grand Rapids. I've had 2 stints in Traverse City. I missed an appointment yesterday with the cardiologist. I've got an appointment at Ann Arbor B Monday to see if they determine if I should have open heart surgery. It's very questionable because of my age, but there is a possibility with the rate cardiologist that they can put a stent in the one that's the hardest to get to. But my guardian is Jerry Benzal. He's in Grand Rapids, and since I moved up there, I haven't had a new one. I'm in the process of getting a new one through the VA. I've had caregivers, and they didn't work out. One of them was told my truck.
The gentleman in Grand Rapids, was that by court order?
No, sir.
Okay, so he
That was
wasn't
my
your
choice.
court. Okay, he wasn't your court ordered guardian?
Absolutely not.
Did he have any legal authority over you?
Here's my power of attorney that I fixed in 2006.
Okay, all right. Mr. Bozac, you present quite a dilemma for the court because you're on bond in Lake County, you're on bond with us, and now it's alleged, and I realize you don't agree with the allegations, but at least as of right now, it's alleged that you committed a domestic violence upon Ruth.
That was self-defense. I've got injury with stitches
Sir,
in my neck.
Mr. Bozac, you have the right to remain silent, and I suggest you do that. I don't want you to say anything that's going to incriminate you in this matter. The prosecutor is in the room, so. When did you say your next doctor's appointments were?
I've got one coming up Monday in Ann Arbor VA to see if they determine if it might be a 60-40 chance for open heart surgery, because the 4 stents are not going to keep me alive for maybe a year or 2.
Okay. Mr. Sharkey, what are the allegations?
Yes, Your Honor. The allegations are that he, while in a vehicle, repeatedly punched his caregiver, Ruth, in the arm, where he was asking her questions and yelling at her, and when she would answer, she alleges that he would say, shout at her wrong answer and punch her in the arm. And this continued until she was able to, at the Wendy's, that they were going to call the police. Law enforcement did observe bruises on her as well, which they did provide photographs of.
What makes it a domestic relationship if she was the caregiver?
They live together, Your Honor.
Okay, all right. All right, the court is going to do the following. As a condition of Mr. Bozac's bond, he is to appear as ordered, keep his contact information current, not leave the state of Michigan without permission, and to commit no new crimes. I'm going to order that the defendant have no contact with Ruth Zirkel. Mr. Bozac, no contact means no contact of any kind, not by phone, text, seeing in person, or having anybody on your behalf contact her. Do you two still live together?
We never lived together.
Okay, all right. Okay.
I stayed with her for a while. I paid rent.
Okay, all right. So the 2 homes you discussed the other day, those are your homes?
No, the home I have is in the Pine River. It needs a new well and electric. So I took advantage of, I offered her $600. She was more than happy with that. I bought groceries. I even bought clothing and for her and her sister, where she abuses her sister being a caregiver.
Okay, all right. I'm going to release the defendant on a PR bond. He's on a $1,500 bond in the other file. I've not been presented with a request to revoke bond on that one. So, Mr. Bozac, you can be released on your own personal recognizance today, but just a reminder, there is no contact with her, all right?
Can I ask you a question, sir?
You can, as long as it doesn't have anything to do with the allegations.
I'm a mother of Mother Nature and pets. She's taking care of my pets right now. And she was supposed to bring the rest of my clothing and pets in yesterday. How can I get my pets and clothing back?
You'll have to talk to your attorney about that once there's been one appointed, and I believe one has already been appointed in your other case. I don't know if you've had contact with him or not, but I've been told that there has been one appointed, so I suspect contact will be very soon.
Thank you, sir.
All right, thank you. We're done with Wexford. Thank you, Wexford.
Thank you, Your Honor.